And a very good morning to you. John Fradgley from the Bell Legal Group, back with you for another program of The Law and You here on 4CRB. It's your opportunity to get free legal advice between now and 9:30. All we want you to do is get on our telephone line as soon as you can, 55208888. That number again, 55208888. Don't forget you can also email us at talkback@4crb.com if you're not in a position to call, but we can only deal with those emails probably in the program next week unless they come in early enough. So ideally, if you can email no later than Monday of each week, we can deal with it in the program as in today. So if you email between now and next Monday, we would be able to do it. But enough of that. We've got a lady who's been waiting very patiently online for some time now. Good morning, Claudia. How are you today?
Hello.
Claudia, how are you?
Oh, not too bad, thank you.
I'm sorry that you had to wait there so long. You've been waiting very patiently since about 5 to 9, so I congratulate you on your patience.
Thank you. I just have one little question.
Sure.
I would like to know at what point an estate becomes liable for probate.
Right. Well, it depends on the value of assets in the estate. There's a number of factors, and it's not like a straight line where above that line you do need probate, below that line you don't. But just as a rule of thumb, normally if there is more than about $50,000 in a bank account, or if the deceased owned shares in publicly listed companies, or if they were living in a retirement village or a nursing home at the time of death, and there's a refundable accommodation deposit to come back to the estate. In the bulk of those cases, you will need to get probate of the will.
The property enters into it, of course.
Only in a retirement village, and depending what state you're in. So in Queensland, as the law currently stands, you don't need to get probate of a will to transmit a property to the beneficiary under the will, but you do need to lodge the original of the will with the titles office when the application for transmission of the property is lodged. And so therefore in those circumstances you would obviously wait until you finish any other steps of administration before proceeding to do the transmission. In New South Wales, unfortunately, you do need to get probate of the will, even in circumstances where that property might be the only asset in the estate.
Yeah, that helps me a lot. Thank you very much.
Okay, Claudia, all the very best.
Thank you. Bye.
And the time on 4CRB is just past 8.5 minutes past 9. The Law and You is the program. 55208888 is the number. Please don't leave those calls for the last 5 or 10 minutes of the program, like last week where we had a huge bank up of calls came in about that last 10 or 15 minutes in the program. It is much better if you can get on that telephone as soon as you possibly can. 55208888. And of course, don't forget, if you live south of the Tweed River, you need to put 07 in front of the number. Now, last week I was talking about some tax issues that surround deceased estates, and particularly things that that executors need to be aware of. And if you're the executor under a will, there are some issues that you need to be very careful about. We were talking last week about the fact that capital gains tax might be payable on the sale of investment properties owned by a deceased person, that there is an exemption for the sale of or the transfer of property which was a principal place of residence, and the sale period is the property must be sold and settled within 2 years of the date of death. However, the Australian Taxation Office on the 27th of June this year issued a practical compliance guide concerning the Commissioner's discretion to extend that 2-year period. And as long as the Commissioner is satisfied that there is a very sound reason for the extension to be granted, then there is a provision to allow extensions for up to 18 months. But you shouldn't simply take it as read that you will get that 2-year extension just because you ask for it. The Commissioner will consider the factors set out in the guidelines and lists 5 mandatory conditions that you must pass to qualify for the extension. So just make sure you take that on board in terms of the sale of a principal place of residence if you're administering a deceased estate. But enough of that. We've got another caller online. As we say, a very good morning to Elaine. G'day, Elaine. How are you today?
Oh, good, thank you.
That's good. How can we help you today?
It's a Queensland question.
Sure.
My granddaughter was left money in a grandfather's will, and it was left to my son to give it to her when there wasn't any stipulation what time, what date she was to be given it. She is turning 18 next month.
Mm-hmm.
Does he have to give it to her then?
Yes.
What he has to when she's 18?
Yes. Well, a person reaches majority at 18 years of age.
Yep. Okay.
Quite often in a will, it may say that that a person is not to receive the funds until they're 21 or 25, etc. It depends on how that clause is drawn as to whether that restriction will in fact apply or not. So, as a general rule of thumb, if there is a straight-out bequest to an infant beneficiary with no stipulation as to age and no alternate provision if they fail to reach that age, then they are entitled to those funds at 18.
Oh, okay. Thank you very much. Now, does she have to ask her father for these funds, or does he just?
Well, he should. He should
not
give
getting
them.
On too well at the
moment.
moment.
I see. Right. Well, if that's the case, then I think she probably should ask for the funds, or she may.
Yes.
Did you say it's your granddaughter?
Yes.
Yeah. Well, it may even require you to intervene with her father just to remind him that the funds are now due and payable.
Oh, okay. Thank you very much.
Okay, Elaine. All the very best.
That's good. Thank you, John. Bye.
Time coming up to 13 minutes past 9. The Law and You is the program. 55208888, the number if you have a question or a query, just like Robin. G'day, Robin. How are you today? Are you there, Robin?
Oh, yes. Sorry about that.
That's okay. How can we help you today?
Yes. Look, my neighbours just asked me last night about this situation. Her son owns an apartment, a little villa, and his girlfriend moved in about a year ago, and it's just on a year, she said, and they're having some discussions about living separately now and about the ongoing relationship. She basically hadn't been contributing anything to the mortgage, she'd just been buying food and things, but I think on the odd occasion she said she may have thrown something in towards it. I was just wondering, or she's wondering what his position is.
I don't think does she work?
Yes.
She has a job, so they're basically just living together. I assume that the electricity, the rates, etc. Well, obviously the rates would be, but the electricity would be in his name. No, look, I don't think he has anything to worry about.
There's been no discussion that would happen, but she was just having some sort of, concerns about what's the what is the law say, really, I guess.
Yes. Well, from memory, I think you've got to be together for 2 years before you're deemed to be in a de facto relationship. But there are other circumstances. That dictate when that relationship comes into existence. So. So the one exception to that, of course, is that if there's a child born of the relationship, then obviously that changes everything. But
no children, and
yes.
And they'd only met about a month before she moved in. So,
yes.
And
well, they've only been together for
earns more money than him as well, so she'd be well in a position.
Yes. No, I don't think there'd be anything to worry about. As I say, that period of time they have to be together, and they have to be together living in basically a connubial relationship. So it has to be a relationship that has all the hallmarks of marriage, and it has to be for 2 years before. That
all right. Well, the 2 years is
definitely sounds like that's not even within the ballpark.
No,
all right then.
Terrific.
Okay,
Thanks,
Robin.
John.
All the very best.
Bye now.
Bye now. And the time just rolls along, 15 and a half minutes past 9. The Law and You, the program, 55208888, the phone number. And we say a good morning to Malcolm. G'day, Malcolm. How are you today? Malcolm, are you there? 15 and a half minutes past 9. The Law and You, the program, Oh, Malcolm, you've got your radio on. You need to turn it off. Good morning to Malcolm. G'day, Malcolm. How are you today?
Yeah, good, thanks, John.
Malcolm, can you just turn your radio down? Otherwise you're going to go insane.
No worries.
You'll hear yourself 10 seconds late.
At the moment. Okay.
How can I help?
Okay. All right. Just quickly, I'll try to keep it as brief as possible.
Sure.
Okay. Back in April of 1999, my sister became the power of attorney for my elderly mother.
Mm-hmm.
Okay, who was at that time then, she was 72. But also, my sister at the time, she was also a director of my mother's company, which was the trustee for my mother's family trust.
Mm.
Okay? All right. Now, what had happened was in 1999, in June of 1999, my mother needed to borrow some money, and she went out and got a personal loan. And my sister organised the paperwork, but unbeknownst to my mother, she'd also signed another loan application in the name of the trustee company.
Mm-hmm.
My sister, I believe, has gone and since plundered that money from the trustee company. Title searches have found that she and her husband purchased a property and they paid cash. What I need to know is, what are the statutes of limitations on this, and has a criminal offence occurred?
Well, the question is whether your mother was aware of what she was signing at the time that she did it. I think from memory you've called once before, haven't you, Malcolm? And I think you mentioned that your mother has passed away.
No, she's still alive.
Oh, she's still alive, is she? Is she still competent?
Yes. No, she's only recently been declared by a geriatrician as being no longer with capacity.
Right, okay.
But that's got to be ratified by the court in August.
Yeah, so I think from memory I mentioned to you that what you really need to do is that you will need to search the records in relation to the company.
I've done that. I've got all that.
So you've got the minutes of meetings, etc.?
That I don't have. What I do have is the deed, company deed, I think they call it.
The trust deed?
Yeah, trust deed, that's it.
Yeah, so were your mother and your sister the directors of the company?
Yes.
Okay, so what you need to look for, and unfortunately you may only be able to find this through the accountant acting for the trust, you need to be able to find the minutes of the meeting of the company where these transactions took place to see whether there are minutes which say that your mother was present and that she agreed to these transactions. Now, Malcolm, it's not going to be an easy thing to do. And whereabouts on the Gold Coast do you live? Which part?
Southport.
Okay, well, what I would recommend you do is take the documentation that you've got already, and I'd ring and make an appointment to go and see the Gold Coast Community Legal Centre and Advice Bureau in Southport, because what you're talking about is far too complex to be able to deal with in the scope of this program, because it would require a review of documentation, and obviously we simply can't do that over the air. But the telephone number for the Gold Coast Community Legal Centre and Advice Bureau, have you got a pen handy?
Yes.
So their number is 5532 9611. So
329611.
Yeah, so if you go and see them, they will be able to outline go and see them with the documentation you have already. They'll be able to go through that and then outline to you the additional documentation that you may require in order to pursue the matter further.
Thanks a lot, John. I'll do that.
Okay, Malcolm, all the very best.
Have a good day.
You too.
Thank you.
And the time on 4CRB is just past 20 minutes past 9. 10 minutes to go with the Law and You. If you have a question or a query, get on that telephone right now. 55208888 is the number. That number again, 55208888. Don't leave it, please, to the last 5 minutes. Get on the phone right now and you'll get straight through. We'll be back after a word from our sponsor.
Are you serious about losing weight? Vita Diet has been helping Australians lose weight and live healthier since 1987. All Vita Diet shakes, soups, bars and desserts are gluten-free, made in Australia and have been perfected over 30 years. There's a Vita Diet eating plan and yes, you do eat real food. Plus, use the Vita Diet ketone sticks to gauge your fat-burning performance. To find out how you could lose up to 3 kilos in your first week, visit vitadiet.com.au for your local pharmacy or call 1300 Shakes. Vita Diet. Time to try it.
Our sponsor.
How long since you have had a skin check? Tweed Skin Cancer Clinic has both male and female dedicated skin cancer doctors, fully trained by specialist plastic surgeons, and they bulk bill. Open Monday to Friday, 9 to 5, and Saturday to 3 p.m, and no referral is necessary. Call our sponsor, Tweed Skin Cancer Clinic, today on 5536 4961.
And the Law and You is the program. 55208888 is that phone number if you have a question or a query. No callers online at present, so if you do have a question you'd like answered, give us a call right now, 55208888. I was talking earlier about issues surrounding tax in deceased estates, and there is a real common misconception that the transfer of assets on death to beneficiaries under a will does not trigger any tax consequences. And I was mentioning earlier that, for example, on the transfer of the principal place of residence, that there is or the sale of the principal place of residence, there is a tax exemption for 2 years from date of death. But if you go outside that period before the settlement takes place, unless you've been able to qualify to get an extension of time, you would very well be up for there very well may be a bill payable. The other common misconception is the transfer of assets to charities. Unless a charity is a deductible gift recipient, in other words, you can make tax-deductible gifts to that charity and the transfer is made to the actual deductible gift recipient charity, then you very well may find that the transfer of a property to a charity under a will also trigger a capital gains tax event and capital gains tax payable. So there are a number of traps there that people need to be aware of, and just make sure that you keep an eye out for those. But enough of that. We've got a couple of callers online as we say hi to Carol. G'day, Carol. How are you today?
Oh, good, thank you.
How can we help?
And you?
Very well, thanks.
That's good. My brother's executive of my mother's will, and also my nephew. Now, I've made arrangements to go down to Sydney and have a meeting with my sisters and my brother. Does my nephew have to come and, because he's the second executive, to have this meeting?
Well, no, he doesn't. It depends whether your brother and the nephew have been appointed jointly as executors or whether your brother is the executor in the first instance, but if he is unable or unwilling to act or dies, then the alternate executor is the nephew. So if they've been appointed together, then he certainly can be at that meeting. But if he is the alternate executor, then there is certainly no need for him to be there. As to whether assuming that they are jointly executors, well, it's not critical that he be there depending on what's going to happen at the meeting. If it's going to be a little bit contentious, then I think it would be a good idea if both executors were present, assuming that he is not simply an alternate executor. So, in other words, if the will says, I appoint my son Bill Smith as executor, but if he's unable to or unwilling to act or he dies during the administration of my estate, then I appoint my nephew Simon Black as executor, then in those circumstances it would only be your brother who would need to be at the meeting. Okay, it's just that my mother's still got her house. She's 99 this year, and she's still got her house. And what my brother's doing is, I can't think of the word, but he's taking the money from the house to pay for her nursing care. Oh, he's taken out a reverse mortgage, has he? Yes. Okay. And I've got two other sisters, myself and this nephew. We all agree to sell the house.
but my brother doesn't want to. Now, can this nephew of mine overrule my brother?
Well, at the moment, if your mother's still alive, the executors are completely irrelevant to what's going on, Carol. The persons who have say in relation to what's going on at present are the attorneys appointed under your mother's power of attorney. So presumably she has a power of attorney. And does your mother still have...
That's my brother.
So he's the attorney. And is the nephew an attorney as well, or is he an alternate attorney?
No, he's not.
Okay, well, if your brother is the sole attorney, then unfortunately it's your brother who has sole control, assuming that your mother no longer has capacity. If your mother still has legal capacity, she can make whatever decision she likes. So she would be able to tell your brother, no, look, I want the house sold. Whether you take out a reverse mortgage or not really depends on the circumstances, and particularly in New South Wales and Sydney, where properties are quite valuable, it may be that, for example, a financial advisor has indicated that you were better, the way the value of property is going up, that you were better to have borrowed the money on reverse mortgage and to pay that back when your mother passes away, rather than selling the property at this point in time. So I think the appropriate thing to do would be to have the meeting with your brother, find out the basis upon which he's declined to sell, or why he's not sold the property to pay the residential accommodation deposit for your mother. She's in a nursing home, is she?
Yes, she is. Yeah.
So
well, she's been in there for 3 years.
Right.
And for 3 years the house has been empty.
Yep.
And it's deteriorating so badly.
Yep. Well, he may be guilty of failing to act in her best interest. So I think it is worth having a meeting with him, pointing all of these things out and asking why he's not arranged the sale of the property. And if you're concerned about the actions he's taking and whether they are in your mother's best interest, then you may need to speak to the New South Wales equivalent of the Adult Guardian's Office, which we have in Queensland. They would have a similar thing down in New South Wales. And you could ring, for example, the Elder Abuse Hotline or Helpline and ask them for the name of the relevant officer in New South Wales that you might need to speak to if things don't go well with your brother. But we'll have to leave it there, Carol. Unfortunately, we're pressing up to the news and we've got another caller online. All the best with that.
Very helpful.
No trouble. Cheers now. Bye. And 28.5 minutes past 9, we say good morning to Barbara. G'day, Barbara. How are you?
Hello.
Yes, Barbara. How can we help?
Yes, I was just ringing to inquire. My husband died last year, and I'm just wondering whether I have to put in a tax return this year. We haven't been doing it over the period of years, so I'm just wondering if I have to.
Are you on the pension?
Yes.
Okay. So, and is the level of income that you have such that you would be required to lodge a tax return?
Well, I don't know.
So your only source of income is the pension, is it?
No, I've got some other money as well put away.
And was that money joint with your husband?
Yes.
Okay. What I would suggest you do, Barbara, I would suggest that you ring Centrelink. They have financial advisors at Centrelink who can assist with queries like this. Do you want their number?
Yes, please.
Okay, so the number is 132300.
132300.
That's their bereavement financial information service. So you could ring them and tell them that your husband's passed away, explain your circumstances to them, and they'll tell you as to whether you need to lodge a tax return or not. It will depend on the level of income that you now have as a result of your husband's passing. Alternatively, if you don't get any satisfaction there, Barbara, ring back on Thursday at the same time at 9 o'clock, and you can speak to the people who are here for Finance Forum, and they may be able to assist you.
Right. Thank you very much.
Okay,
Yes.
Barbara, all the very best. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning for today's edition of the Law and You. I'll look forward to being back with you again next Tuesday, but as always, until then, it's goodbye and God bless.